Welcome everybody. It's great to have so many people joining us. As you know, September is known as the Will's Month, and hence this webinar that we're going to discuss all about wills today. Our presenters, or let me share the screen first. The topic that we're going to discuss today is the last will and testament. What constitutes a legally valid will, and what are some of the pitfalls to consider when drafting a will, your will. Presenters is Salochana Packery and myself. Just to introduce you to Shalosh, she's an admitted attorney, and she soon will be admitted notary as well. She's done and completed the lead course. Has got more than 14 years of specialized deceased estate administration experience, both in the corporate world and in private sector. In her current role as the head of the Deceased Estates and Wills Department, as well as the acting head of our bond department. Salochana leads, manages and develops staff and internal process to achieve the highest possible standards of service delivery. Her role also involves the personal interaction with clients, at which time various aspects of the estate administration process are discussed. Thank you for everybody for attending this very interesting seminar. And I'm going to hand over to Shalosh now, and then she can start with her part of the presentation. Shalosh.
Good morning, ladies and gentlemen. Welcome to our Wills webinar, and thank you for joining. This morning, I trust that you will find our session informative and useful. Now, I'm sure all of you would agree that over the last 2 years, there's been an urgency with many people to get their affairs in order. We personally have seen an increase in the need for the drafting of a will. And over the lockdown period, one would have seen that people were scrambling to get some sort of document in place that purports to be a legal valid will. Now, unfortunately, in many of those instances, what would have happened is the mandatory requirements for a valid will in terms of the Wills Act 7 of 1953 were not adhered to. So this morning, I'd like to go through those requirements with you and just touch on some important factors that you need to take into consideration when drafting your will. Now, the requirements in terms of the Wills Act is firstly, a person making or drafting a will needs to be over the age of 16 and over, and must be competent to make such a will. Now, the word competent does not only relate to the ability of the person to draft a will, but it also relates or pertains to the understanding of that person in terms of what they have executed and the consequences of their actions, or what the actions would be after the drafting of the will. The will needs to be in writing, and that means the will can be typed or handwritten in terms of the act. Very important to remember that if the will is handwritten, the person writing the will, that means if the person other than the testator is writing up the will, that specific person and his spouse will not be permitted to inherit from the estate, except for certain provisions that we're going to discuss a bit later. The will, if it consists of more than one page, must be signed on every page, including the last page, by the testator. The will must also be signed by 2 competent independent witnesses. Now, what makes a competent or independent witness, I'm just going to my next screen. Just a moment for me. Now, what qualifies a person to be a competent witness is if he or she is 14 years of age or older and such witness at the time of witnessing the will should be competent to give evidence in a court of law. So they should understand what exactly they are witnessing and attest to being present when the testator signed the will. The will must be dated in order to eliminate any confusion as to which is the last will of the deceased or the now deceased person. If the will is signed by the testator by a making of a mark or by a thumbprint, or by the testator directing that someone else, a third party, can sign on their behalf, this needs to be done in the presence of a magistrate, a justice of peace, a commissioner of oaths, or a notary public who will certify that the testator has been identified to him or her and has been satisfied that the will was in fact signed by the testator or at the testator's direction. And if the will consists of more than one page, each page will be signed by the officiating officer. Now, I have taken excerpts of a will, and I'd like to go through this with you. It's generally how we have our wills consultations with our clients, where we actually go through what the will contains and go through each clause to explain this in depth to the client. First of all, the will starts with a heading, and it either indicates a single will or a joint will if there's more than one party drafting or drafting the specific will. This instance, it reads the joint will and testament. This is the last will and testament of Robert Nielsen, identity number, and Denise Nielsen, identity number, married out of community of property. Now, the spelling and the noting of the name is very important, and it needs to correspond to how it appears in the identity document. The identity number also needs to be checked very carefully. A mistake of a digit of an identity number can have dire effects later on when the estate needs to be administered. The note of the marital status of the parties is also very important, and this could have an effect on the administration of the estate. So, for example, there would be a marriage out of community of property, married in community of property. And if the parties had to marry, for example, in London or be married in the UK, it's important to state that on the will, married in terms or according to the laws of the United Kingdom. Very important, that has an effect on the administration of the estate. The next clause that one brings in is a revocation clause. And the revocation clause in simple terms means to cancel any previous wills. So it would generally read, we hereby revoke, cancel, and annul all previous wills, codicils, and other testamentary acts made by us and declare this to be our last will and testament. Now, the effect that this would have if you do not bring a revocation clause in would mean is, for example, if you had drafted a will last year sometime, and in that will you were in a relationship and you nominated your partner to be the sole beneficiary to your estate, all good and well. This year, unfortunately, you broke up and you changed your will and you decided to leave it to your two children, but you failed to bring in a revocation clause in this year's later will. The effect thereof means that you did not revoke your previous will, and both wills will need to be read together to give effect to the distribution of your estate. Very important clause to take into consideration. Now, you must have heard the term that there is a freedom of testation. That simply means that the testator has the freedom to dispense of his estate or his assets in his estate as he deems fit. That just means that I can leave my entire estate or specific assets to whomever I please. I do not need to leave it to a specific person. But this is contained in the bequest clause. So very important to note that one can specify assets in the bequest clause. In this instance, for example, it says 2.2.1, if you follow with me, the BMW motor vehicle of the testator to the brother of the testator, Sam Nielsen. 2.2.2, the jewelry and items of a personal nature of the testatrix to our daughter, Jessica Nielsen. So there's very specific bequests. But what's also important to note in this bequest clause is a mention of what must happen to the rest of your estate. 2.2.1 and 2.2.2 only make note of certain assets. What happens to the remainder? And that's why 2.2.3, the residual clause, is imperative to bring in to your estate and specify who inherits the residue of your estate. Also very important to note in a bequest clause is if it's a joint will and you're wanting your surviving spouse to inherit, there is a possibility. Think of the scenarios where the possibility is you're driving together and both of you meet up with an accident and both of you pass away at the same time. Who would then be the beneficiary to your estate? So it's always advisable to bring in a succession clause. In this specific wording we use, we mention, we hereby appoint the survivor of us to be the sole and universal heir of the whole of the estate, property and effects of the first dying of us. Simple terms, what that means, if husband passes on first, then the wife is the sole beneficiary. And 2.2 says, in the event of us dying simultaneously, or the survivor dying without leaving a further valid will, then the other clauses come into effect. So that's providing for when both of you are not here. Now, we often approached by clients who say, I want to leave my estate when I pass on to my son, but I don't want my daughter-in-law to inherit. And they ask for what protection is there available for my son. And this is the solution, the Marital Protection Clause. It's a standard clause that we bring into our wills. It's a general clause brought into wills that says, and it reads as follows: all bequests and any income therefrom derived from time to time in terms of this will shall be excluded from any legal consequences of any current or future marriage, whether in or out of community of property. In simple terms, what this means, everything inherited by your beneficiary will be excluded from their marriage, whether they're already married or whether they are still to be married or whether they are to be divorced. Their spouses cannot lay claim to what they inherit. Very important to note here is that this clause is enforceable in the instance where there's a fixed property inherited by a beneficiary. We can endorse it against the title deed, or the deeds office endorses the specific provision against the title deed. But when it comes to cash, when your beneficiary is inheriting cash, it's very difficult to distinguish that it has actually been received as an inheritance from an estate, unless a proper paper trail is kept by the beneficiary to separate and distinguish their inheritance in comparison to other funds they may have. So unless your beneficiary is keeping a separate bank account where inheritance will be placed in, potentially, a spouse can lay claim to this. And also if the heir freely gives the funds to the spouse or leaves the inheritance subsequently to her spouse to inherit, there's unfortunately nothing that one can do in that instance. But generally, this is the Marital Protection Clause that one brings in. The next clause is the Executor's Clause. The Executor's Clause. And the Executor's Clause reads as follows. We nominate and appoint, in this instance, Jan L Jordaan Incorporated attorneys as executors of our estate. We instruct the Master of the High Court to waive security by the said company for the proper performance of its duties in this capacity. the nomination of executor is awarded with the relevant power of assumption. Very important to bear in mind that in a will, one can nominate an executor, but it is the Master of the High Court who actually appoints the executor. The Master also has the discretion not to grant the issuing of the letter of executorship or the appointment of the executor in an instance, for example, where there is a complex estate or an estate where property, etc., needs to be dealt with, until the Master receives an undertaking from a legal professional or trust company, as it may be, to assist the nominated executor to carry out the duties as stipulated in the Estates Act. That is in the instance where an individual is appointed as executor. Important clauses to note is the clause of the waiving of the provision of security. If that is not stipulated in the will, there is a provision in terms of law where security needs to be provided to the Master of the High Court. And then also the wording, the nomination of executor is awarded with the relevant power of assumption. That simply pertains to the fact that the executor has the discretion and the authority to appoint a co-executor if need be. So that is how the executor's clause is usually cited. A trust clause, one must bear in mind that if your beneficiary is a minor child that is under 18 years of age, or if your beneficiary is your surviving spouse and you need to make a special provision for the spouse who may be in frail care facility, or you may have a disabled child, this is potentially where a trust clause comes into a will. Now, this just means that the trust will be established only at the death of the testator. It is commonly referred to as a testamentary trust or mortis causa trust. And one needs to look out for certain things. A trust clause can be as lengthy and comprehensive as you wish it to be, or it can be very brief depending on what your instructions are. But certain factors that you need to take into account. Number one, definitely to create a trust clause when there are minors concerned. So you have the discretion of deciding, do I make the entry age at 18 or do I make it later? So that would mean if your beneficiary is, and in this instance, it's 21 years old. In the instance where your beneficiary is 15 years old, when they inherit from your estate, that means they will not receive the inheritance in their hands. A trust will be formed and it will be held in trust by the trustees until they're 21 years old. Obviously, for the duration of the trust, certain provisions as provided in 7.1 right up to 7.9 or 7.10 would be trust provisions to provide for the maintenance needs of that specific trust beneficiary. It's also very important to note a trust termination age. So one needs to bring in, as indicated in 7.8, that the trust specifically is to terminate when the beneficiary attains the age of 21 years old. It's also, one needs to bear in mind what happens when a trust beneficiary passes away. So one has to make provision for that scenario as well. And a common clause that one would bring in is, should the trust beneficiary pass on during the existence of the trust, that a third party that you nominate would then be entitled to inherit the remaining balance as it then exists, and any capital or income as it then exists, and the trust is to terminate. Very important, and what one must not omit is the nomination of trustees. Also here, one waives the provision of security to the Master of the High Court. Just remember that if your beneficiary is under the age of 18 years of age and you do not make a trust provision, their inheritance needs to be paid to the Guardians Fund, the Master of the High Court's Guardians Fund, as stipulated in legislation. Now, a guardian's clause is sometimes what people bring in, especially those young parents who have minor children. The concern is always for their young children. And the question is, who would look after my children if I'm not here? Now, this specific clause reads that failing a natural guardian, we appoint the brother of the testator, Sam Nielsen, and his spouse, or the survivor of them as the guardians of our minor children. We direct that the said guardians shall not be required to furnish security for acting in that capacity. One has to bear in mind that the natural guardian, who is the biological parents of the children or child, has the strongest right, hence the wording failing a natural guardian. So only in the instance where both parents have passed on and one wants to bring in a guardian's clause, this is where you would nominate a guardian for your minor children and contain that in the will. But you must note that it's not as easy as nominating a guardian in your will, and that is then legally binding on the guardian. It's always important to discuss this with the person you intend nominating, because taking on guardianship of a child is a huge responsibility, number one. Secondly, what needs to be considered, that guardianship application is a court application. So although you indicate in your will that who the guardian should be, they still have to undergo the process of the legal court application to be appointed legally as the guardians of the minor children. A clause that we bring into our wills as well is known as collation. Now, the collation clause would read, it is a specific condition of this will that any benefit which may have accrued to any beneficiary during our lifetime will not be taken into consideration in terms of any inheritance derived from our estate. So the collation clause, if not brought in, would indicate the following: that if you had given, if your will stipulates, I bequeath my estate equally to my 3 children, and perhaps during your lifetime you've given child 1 a Ferrari and child 2 1 million rand and child 3 only 50,000 rand, and your collation clause, if it stands as we've stipulated here in the wording, that means that what you've given to your children during your lifetime, you've done so freely as a gift to them. And we do not need to take that calculation into consideration when they receive a benefit from the estate. The other interpretation of this would be is if you gave those items to your children during your lifetime, and you want the inheritance when you pass on to be on an equal footing for all children, typical scenario where the kids say, it's not fair on me, I've received less than the others, that type of thing. And this is where you bring in the provision in your will saying that what you've given to your beneficiaries during your lifetime needs to be taken into consideration to ensure the equitable and fair distribution to all beneficiaries. And this is where you could specify certain items left to them and also confer certain duties on the executor. For example, if it's property, if it's multiple properties that you're wanting to bequeath, you would say in this clause that a valuation, market-related valuation, needs to be done to ensure the fair and equitable inheritance by all beneficiaries. The special wishes clause, normally what we approach just to bring in a request for the testator wanting to be cremated. This is where we bring it in, and a simple clause would read, it is our wish that our mortal remains be cremated and our estate is to bear the cost of our cremation. Sometimes we do get a request that the ashes need to be scattered at a specific place, or a plaque be erected in remembrance of the testator. Whatever the special wish is, it is 100% perfect if you bring it into the will. But bear in mind that the will generally isn't the first document that family members grab when someone passes on. So it's very important that you convey your wishes to your family members so that they are fully aware of it and they can execute your wishes at the appropriate time. You wouldn't want to sit with a scenario where your will says, I would like to be buried next to my mum, and children decide to cremate you and they find the will and oops, it's too late. Nothing can be done about that. So very important, although you bring special wishes into your will, remember you need to convey that message to your family beforehand so that they understand exactly what your wishes are. This is just an example, an excerpt from one of our wills and or fictitious will, so to speak, and it's an example of how a complete 2-page will would look. So as you can see, it is the heading that we've gone through, stipulating the full names, ID numbers of the parties, how they are married, the revocation clause, very important, the bequest clause, the marital clause, executor, trust provisions, collation, special wish, and also very important to note that provision is made on the 2nd page for a date. On the 1st and 2nd pages, you will note that provision has been made for the testator and testatrix to sign their wills on each page as per the legal requirements. And the witnesses, although it is a requirement only for the witnesses to sign the last page, it is good practice for them to sign every page. I would like to hand over to Jan now, who's going to take you through some of the pitfalls that we encounter when drafting wills. Thank you, Jan.
Thank you, Shalosh. Yeah, that's more the legal side of it and the practical side of it. Let's have a look at the pitfalls when drafting a will. Let's have a look at a few things. Simple facts to consider. We always say to people they must avoid legal jargon, use clear and simple language to speak speak to the intention of the testator. Sorry, I always say to people, the test is actually, you should give your will to a third party. Let him or she read it and tell you what she understands from your will. Because sometimes I've seen wills that's pages and pages long, and it's just legal jargon, and you actually don't get to the actual point. Second point, be very careful to cut and paste from other wills without understanding the legal consequences thereof. It could bring about a contradiction in the will and render your will invalid. So be careful. If you are planning to do your own will, rather do it, send it to specialists like ourselves to check, and then we can assist you. The next point I'm making here is that it's very important that if you nominate a trust company, a trust or a company in your will, you should actually make sure that that company or that trust has been registered. We've had it before where a person say it must go to a trust, his assets, and then the trust is not registered. And you can only imagine all the consequences coming from that. Be attentive to the correct spelling and grammar. A simple example I use here is I leave 1 million rand to my children as opposed to I leave 1 million rand each to my children. Now, I think there was a court case where the testator said, I leave my house and contents of the house to whoever, but there was a typo error, and he typed it in, I leave my house or the contents to my children. You can only imagine the issues that there were in that matter. So check the spelling, check the grammar. A simple spelling error can make a huge difference. Even where you put a comma in can make a big difference. A will should always state who will inherit the residue of or the balance. Shalosh has discussed that. It's very important. I often get people say, but I don't have much. I've only got a car and a house. Yes, ma'am, that's true. But by the time you die, you might have another car or another property. You might have furniture, jewelry, etc. So the residue is very important. The bottom point we're making here is when you have assets in another country, sure, it's so important. We always advise our clients to have 2 wills, one in that country, let's talk about the UK, and one in South Africa. Have one specifically for your assets in the UK and one specifically in South Africa. We don't always know what the rules and regulations and laws are for the legal valid will in other countries. So it's important that you have a proper will done by a specialist in that country. It makes the winding up of the estate so much easier as well. Because if you pass on, they can then, let's say in the UK can start immediately with winding up the estate, report it to their master of the High Court, which whatever they call that, and then we can start here in South Africa. One point that is very important, be careful. Charlotte discussed it as well. You normally revoke your previous wills. If you put in your will, I hereby revoke and cancel all my previous wills, and you go to the UK and you've got a similar clause in that will, and you say in your UK will, I hereby revoke and cancel all my wills, then effectively you're cancelling the will in South Africa. So be careful on that point, that you don't cancel a will that you don't want to be cancelled. Yes, we can tell you long stories about this point. I say if you know that the heirs do not get along, then rather specify who should inherit what. You know, the benefit of, and I'm punting myself now, of our business now, is we do wills and we do administration of deceased estate. So we see what happens after death, winding up the estate. We've got a few estates that we're winding up where the children, the siblings are fighting. You just don't understand it. I always say that when money is involved, the rules change. So if you know your children don't get along and you want them to inherit, rather specify what each of them should inherit to make sure that there aren't any issues. Charlotte also discussed this with nominating an executor or trustee. Ensure that you instruct the master to waive the security. By law, if you're not the parent, the spouse, or the child, you have to provide security to the master. That means you have to take, in simple terms, you have to take out insurance equivalent to the value of the estate, that should you as the executor, let's say, steal the money, pay it out to the wrong person, then the insurance will pay out. We always say to clients, if you don't put that in, or you don't want to put that in, or go one step back, if you don't trust the person you nominate as the executor, then you should not nominate that person as the executor. Always have a succession clause. We've discussed that in when Charlotte discussed the wills. It's not necessary for the witnesses to state their name, surname, ID number, or contact details, but it's a good practice to do it. You know, you don't always recognize, especially if it's years ago, who signed as witness. And if there are witnesses, and if there are issues, and you don't know who signed it, with a name and a number, then you can always follow that up. Making a will, drafting a will, be aware that farms and agricultural holdings cannot be subdivided without the consent from certain authorities. So if you put in your will that a property must be subdivided, make sure that you understand what it's all about. Last point on this, on page 17, it's also important when you do your will, when you prepare or draft your will, and let's say, use an example, my house must go to my son, but it's fully bonded. Have you taken into consideration what should happen? Is he supposed to pay the bond off himself? Is the estate supposed to pay the bond? You know, have you got life insurance that you should see to the bank that the bond gets paid? So take all of that in consideration. Think about cars that you buy on credit. You know, who's going to pay the car or the house before it's transferred to your heir. Common errors is spelling errors of your beneficiaries. Make sure that you get it right. You know, good advice is always, in some families, especially the Afrikaans families, you've got family names. You say little Johnny must inherit, but you've got Johnny your brother, Johnny your dad, Johnny your uncle, etc. Specify who it is. Johnny my son, or my brother Johnny, etc. And if needs be, you can always put their IDs next to their names, or even their dates of birth, to make sure there's no problems after death. Also, and we've discussed before, make provision if the nominated beneficiary were to predecease you and you don't change your will, what should happen to your assets. Then this point, leaving assets to minors under the age of 18, failing to make provision for it, whatever a minor will inherit will go to the guardian fund. Whoever is the guardian can then claim a certain amount per year for the maintenance of the child. But it goes to the guardian fund, which is controlled by a government department, more specifically the master. Need I say more? It's so important that if you do have heirs that might be younger than 18, is to rather state that a trust must be formed, a mortis causa, which is a trust that will be formed after death. And then also nominating your trustees should be people that you trust, because they're going to control the money on behalf of your children. You need to make understand that the money will always be available to the children, but at the discretion of the trustees. And you need to, my advice is that you need to educate your trustees as well, what you actually want from them and what you want them, the money, what should happen to that, you know, like a tertiary education, etc. We've mentioned it before, nominating a trust as a beneficiary while the trust is not registered. We're talking about a trust that you think was registered before your death. Get the correct facts regarding your assets. You know, often a property is on the corner of two streets, but your entrance is in the street, the one street, but the property is actually in the other street. Make sure, that might be a simple example, but make sure that the assets that you specify, you specify it correctly. And I've seen this before. You cannot bequeath an asset that does not belong to you, stating what should happen to trust assets. You know, I'm not going to go into it. That's a webinar for another day. People use their trust as their alter ego. And then there's a property, for instance, that's registered in a trust. But because they're using it as their alter ego, they think they can, in their will, say that the property must go to ABC. Meantime, it's in a trust. You don't have that authority to state in your will what should happen to an asset that doesn't belong to you. There's more to this point, but for now, just be careful that you can't bequeath an asset that doesn't belong to you. I just want to make sure that I didn't skip a page, page 19. Statutory provisions in terms of the Wills Act, Section 2B states that if a testator or testatrix, obviously, that's male and female, dies within 3 months of becoming divorced, and that testator executed the will before such divorce, and where that person nominated his now ex-spouse as the beneficiary. Now, this is the point here. The will shall be implemented as if the previous spouse had died before the date of divorce. Make sure of those things. If you get divorced, make sure that you change your will, unless you want your ex-spouse to inherit whatever you have in the will. Section 2C, surviving spouse and descendants of certain persons entitled to benefit in terms of a will. Now, if your spouse and your children are heirs to your estate in terms of your will, and your children, for instance, or a child renounces his right to receive such a benefit, his share will automatically go to the spouse. Did you get that? You get spouse and children. They are the heirs in terms of the will. The children or a child renounces his right. Whatever he was going to inherit will go to the surviving spouse of the deceased. Section 2.3, if a court is satisfied that the document or the amendment of a document drafted or executed by a person, I'm not going to read it, I'm going to explain it to you. If you did not comply, if the testator did not comply with all the rules and regulations of the Wills Act, you can approach the court in terms of Section 2.3 of the Wills Act and ask the court to accept that document as the person who passed on as his last will and testament. But why go through all of that? Because now it's a Supreme Court application, there's advocates involved, there will be an attorney involved, it will cost you a few £1,000. Why go through that if you can do the will perfectly the first time? Section 4A, Charles touched on that. It says that if a person signs as a witness and his wife, or his spouse rather, or wrote the will in his own handwriting, that person will be disqualified in receiving any benefit from that will. So, use an example. The spouse signs as a witness, or the child signs as a witness, or again, another child writes out the will. They are disqualified to inherit from it. There are exceptions, but again, rather make sure that the people who sign as your witness are independent in terms of your family tree. Now, 4A, then the 1A, a court may declare a person or his spouse referred to in subsection 1 to be competent to receive a benefit from a will if the court is satisfied that that person or his spouse did not defraud or unduly influence the testator in the execution of the will. From that, we can see that's the purpose of that, to make sure that people are not unduly influenced to make a will. And therefore, we've got the Act. So B states that if you have signed as a witness, or you wrote out the will for the testator, you can only inherit as much as you would have inherited if there was no will. Let me explain. If you die without a will, you die intestate. In simple terms, the spouse and the children will inherit in equal shares. There's lots to it. That's just for the purpose of this discussion. The spouse and the children will inherit in equal shares. Now, let's say there's one spouse and 3 children. It means each person will inherit 1/4. Now, if you're in this scenario, you will only be able, if you sign as a witness, you will only be able to inherit 1/4 of the example I used. Right. So I can't stress it enough. Your witness must be an independent person that signed your will. Amendments to the will. You can, the law allow you to make amendment to the will, but when you do that, make sure that you get, that you sign and change it in the presence of 2 witnesses, independent witnesses. It's not necessary that the same witnesses that signed the original will that sign your amendment. But you need to get 2 witnesses, sign in their presence, let them sign with you, and then date that amendment. All right. A codicil makes reference to the original will, however, brings certain amendments. Now, codicil is like an amendment to a will. All good and well. The same rules apply. It has to be signed in the presence of 2 independent witnesses. You as the testator has to sign it, etc. But be careful. A codicil is a separate document, and it's not filed and attached to the original will. It's easy to be lost. A typical example is where somebody picks up a will and there's a codicil, and he reads the codicil and he thinks, with this codicil, I'm going to lose out. Tearing up the codicil and throws it away, nobody will know about it. So my advice is always, if you want to amend your will, rather let's do the will from start. We do it completely over. We do a new will. Yeah, just as I've discussed, should you wish to have a codicil done, then the same requirements for a valid will are applicable. Choosing your executor, people, that's so important. I think what you should do is, if you nominate somebody as an executor, is just to chat to him and make sure that he is willing to do that. Because if you've nominated Joseph and you pass on, nobody can force or force Joseph to be appointed as the executor. So maybe it's a good thing to discuss it with him. Also, think it's a good thing to, or if you think who you should nominate, the first thing that should come to mind is trust. Who do you trust? And you can appoint that person as the executor. If you nominate beneficiaries that have not been born yet, a typical thing that we see often is to all my grandchildren. Now, remember, if you say all my grandchildren, it means any future grandchildren. They might not even been born yet. So practically what it means is, if you say all my grandchildren, you pass on and your children are still able to have more children, then you can't wind up the estate because there might be more grandchildren. So it's very important to say, they rather add in, say, in all you nominate the beneficiaries, say to all my grandchildren that are alive at the time of my death. Then we can finalize the estate easily. Next point, understand the difference between an heir and a legatee. A legacy is a specific sum of money or assets which a testator bequeaths to a person known as a legatee. The legatee differs from an heir in a will in that an heir is the person who succeeds to the residue of the estate after all the debts, costs, and administration to the estate and estate duty have been paid in full and all the legacies distributed. To use an example, I say my friend Louis must inherit 100,000 rand. He will be first in line to inherit from me. We have to pay Louis first his 100,000, and the balance will go to the children after all the debt has been paid. Just another example, the 100,000 to Louis. Let's say your estate is only worth 90,000, not 90,000, yeah, 90,000 rand. Then only 90,000 will be paid to Louis, and your heirs won't receive anything. People, I see there's a problem here. Sorry. So understand the difference between an heir and a legatee. All right. Update your will on a frequently when events such as marriage, death, and family member divorce or having a child takes place. People always ask me how frequently. There's not really a date or a time period dated or linked to it, but when things change in your life, you have to update your will. The record, if I can call it a record, that I have is that I had a couple here. The last time they updated their will was 57 years ago. So you can imagine how many things have changed in the last 57. So it's so important to update your will on a regular basis. The last point, make practical bequests that your executor will be able to execute. Do not rule from the grave. A typical example that we often see, people say, my property must go to my children, but they are not allowed to ever sell it. That is just so impractical. I mean, so many things could happen. They could immigrate. That area where the properties could, the value could drop, and now they can't sell it. So make it as simple as possible, and which is something that can be executed. And remember not to rule from the grave. All right, people. That's our presentation. I'm going to have a look at the chats now, and let's see if we can answer your questions. First two questions is not really. Let me go down here. Sorry, I'm I'm trying to go down this. Yeah, here we are. With regards to testamentary trust, why 21 and not 18? Very simple, Michael. You have a choice how old your heirs should be before they actually get it. The question I always pose to my clients, I say, can you remember when you were 18 and what would you have done if you received a few thousands or millions of rands? My personal advice is always to make it 25, never mind 21. It's all about your heirs. Can they handle, are they mature enough at the age of 18 to deal with the assets that they inherit? Shalosh, are you there?
I am here, Jan.
Can the termination date of testamentary trust be left in the discretion of the trustees, i.e. not specify an age upon which the trust would have to terminate? Shalosh?
It's always advisable to bring in a termination age in your testamentary trust. Remember, the other type of trust is what is called an inter vivos trust, which is what you create during your lifetime, and a trust deed holds what must happen to that trust for the duration of the trust. So your one shot at what should happen to your testamentary trust can only be brought into your will. So it's advisable to put in a trust termination age in your will. You know, also what we bring in, and you may have noticed on our presentation, is what we generally bring in a clause that speaks to the fact what happens if the trust runs out of funds or cannot be established because there are no funds. Which can happen. It's a reality. So it makes our clause makes provision for that scenario as well. So if there's insufficient funds, that is also speaks to the termination of the trust, which will be concluded by the trustees then.
Jock, in short, yes, you can do it, but it's not advisable. It's advisable to have a date in there or age. Good morning, Jan. I've experienced legal entities folding after the managing partner passing on. What guarantee does Jan L Jordaan afford the individual to such an instance? Ron, obviously nothing is guaranteed in life. I have got a succession plan, but again, it comes back to the point that you need to update your will on a regular basis. I mean, you can nominate Joe Soap to be the executor, but what guarantees that he'll be alive and that he can attend to the winding up of your estate? So I hear you, good question, but you need to update your will on a regular basis. Is it advisable for couples to create a joint will or single will, and what is the advantages and disadvantages? I hope I pronounced your name correctly, Mdlu. It's exactly the same thing. As far as I'm concerned, there's no advantage or disadvantage. It's two documents that you combine in one document for a joint will, so doesn't really make any difference. Shalosh, your thoughts on that?
Yeah, it's really the preference. The consequences of that would be if one has a joint will and its spouses drafting the joint will, at the death of the first spouse, the requirement is to lodge the original will to the Master of the High Court. So the only technicality comes in is if the survivor fails to make a later revised will, then at her passing, an originally certified copy of that joint will first needs to be obtained from the Master of the High Court before commencing with the reporting of the survivor's estate. So that is the only technicality. So what would the advice would be? Yes, as soon as the first spouse passes on, to revise your will as quickly as possible, or the other option and solution would definitely be to do separate wills.
Okay. Bonnie, if you have assets in two countries, do you need two wills? You don't have to have two wills, Bonnie, but it's advisable. I have explained that in detail. Michael, I leave 1 million each to my children. Is my children not too vague? Would it not be better to name each beneficiary and heir with full names and the identity number, and refrain from using classes such as my children or my grandchildren. 100%, Michael, I agree with you. I just try to make the point that if you add the word each or leave it out, what big difference it could make. You're 100% correct. Specify your beneficiaries, but make sure that the grammar and the spelling of the will, the writing in your will is correct. Philip, what other formalities have to be complied with outside of the nomination in the will to ensure that the guardian is properly appointed? Philip, I'll answer that, and I'll ask Shalosh to add to that. The highest authority in South Africa over children is the High Court. So if ever it happens that there are issues, as far as I understand it, the High Court will make a final decision, and the nomination in the will obviously count towards or assist the judge in making a decision on that. Shalosh, have you got anything more to that?
Yeah, as I mentioned earlier, the appointment of a guardian in a legal capacity would be a High Court application. So one would have to follow that process.
Okay.
Yeah, sorry, I just want to mention, I think you are going down the questions in the chat box. I know Harry is waving his hand for quite some time. So I don't know if you want to go to Harry.
Sorry, Harry. I couldn't see you. I don't see you. So, Harry, have you got a question? Let's go through the chat box, and then afterwards we'll give the opportunity for people to ask questions. Okay. Will this slide be made available for the attendees? Yes, we will do so. You would just need to request a copy of that, Rahini. Lee, could you expand on what is known as a worldwide will? If you have a will in another country, how are the wills coordinated to wind up the estate in 2 or more countries? She carries on, in situations where children born outside of a marriage that the spouse was not aware of, how is this dealt with, especially if this is a minor child? I think that's a bit of a separate question. We'll get to that now. Lee, I think a worldwide will could be dangerous in the sense that not all the rules and regulations and laws are the same in all the countries. Therefore, we advise clients to have wills in separate countries, because we don't know the rules for drawing up a will in other countries. I mean, there are hundreds of other countries, and every country has got its own rule. To coordinate the wind up of the estate in the 2 or more countries, that's the point. If you've got a will in South Africa, it will be done in terms of the South African law, and if it's in, let's say, the UK as an example, it will be done in terms of the UK rules and regulations. So it will be 2 separate estates that's wound up in 2 separate countries. Shalosh, in situations where children born outside of a marriage that the spouse was not aware of, how is this dealt with, especially if this child is minor?
So obviously, in a will, if you are bequeathing your estate to specific beneficiaries, then only those specific beneficiaries would inherit. In an interstate estate where there's no will, then yes, that specific child born out of wedlock would factor in as a legitimate child of the deceased and would be entitled to an inheritance in terms of the Interstate Act. But potentially a minor child who's been excluded from inheriting, where there is a will, could potentially have a maintenance claim lodged against the estate for reasonable maintenance needs. So that's how one would handle a child, a minor child that's not been covered by a provision, by any sort of testamentary provision or by the Interstate Succession Act.
Okay, where the testator made provision via life cover and nominate beneficiaries on the life cover, but did not provide for credit, debt, etc., bond cover, etc., how would the estate be wound up in this case? So, Lee, if there's a beneficiary who received the the life or the payment of the life cover, but there's no specification that what he should do with it. You can't force that person to pay for the bond, etc. So it's actually two separate issues. If you do have a property and there's a bond over the property, registered over the property, you have to deal with it. So you will approach you might have to sell assets in the estate to cover the bond, or you might have to approach the heir and say, do you want the property? We don't have enough assets to cover the bond. We have to sell the house just to pay the bond, or are you prepared to take out a bond, or are you prepared to settle the bond, and then we transfer the property into your name? I hope I've covered that question. Also, with regard to funerals, usually this happens soon after death, often before the contents of the will is known. How is this handled if the person wanted to be cremated or buried? Shalosh?
I think I covered that in my discussion, and what I mentioned was that's a reason why it's very important to make your wishes and your last funeral rites known to your family members or closest friends, which can be carried out accordingly. Like I said, the will isn't the first document that people grab when you pass on.
Yeah. It also boils down to estate planning. I mean, if you pass on now, a funeral will cost anything between 15 and 25,000. Who's going to pay for it? And if there's not money available, where's it going to come from? Normally, in practice, what happens, a family member pays it, or a spouse or children pays it, and then they just claim it back from the estate. Ron, Jan, I think you and I should have a discussion. The succession plan of legal entity. Jan Jordaan, I think need to regularly update the will. Ron, that will be great. Thank you. Kagiso, what happens if there is a joint will and a few days later one partner decides to have a single will and advise that the other partner is not supposed to know about the single will? That's the thing, Kagiso. When you drop a will, you can change your will or amend your will if it's a joint will without the other person's knowledge or consent. So the last will then be the last will of the deceased. So yeah, that is exactly what happens. The will still be valid for the person who didn't change it, but the person who changed it will have a new will. Timothy, if I have a business and I die and won't like the business to proceed, how to handle funds in the business name to be allocated to the children and spouse? Shalosh?
So one needs to remember that a business is a separate legal entity from your estate. So you can contain a clause in your will that specifies what should happen to the business. For example, where a general clause would bequeath the entity or your entire estate holistically to your beneficiary. Your clause could specify that the business be liquidated as such and sold. You can even indicate who would be the preferred purchasers in that specific industry to your business entity, and then what must happen to the funds and who must inherit those specific funds. So the practical execution of that would be an accountant involved together with the executor, liquidating the entity as such, selling off the business assets, liquidating the entity, deregistering the entity so that it obviously ceases to exist, and then any dividend or any funds available from that sale paid to the estate and distributed as per your wishes. The other option or solution obviously is if you have other partners involved in the business, is by way of a buy and sell agreement where you can bring into place to provide for when you are no longer here. So that is another solution.
Timothy, it all boils down to estate planning. Fani, thank you, Jan, very informative. Can beneficiaries fire an executor? Can beneficiaries fire an executor? No, unfortunately not, Harry. What you can do, the beneficiary can approach the Master of the High Court and give reasons why he would want the executor to be removed. But the beneficiaries on their own don't have the authority to fire an executor, as you stated. All right, Lee, thank you. Appreciate it. Thank you, Insight, Jan Jordaan. Thank you, Jan. I've learned a lot. Looking forward to more webinars. Thanks, Kagiso. Heather, if one places a clause in single or joint will that either spouse cannot change will without knowledge or written consent of the other spouse, is this even legal? I've never really dealt with it, but I don't think it will be legal because we have freedom to draw up our own wills, etc. So I don't think a court of law will accept that. Shalosh, I'm not sure if you've got any opinion at that point.
That's 100% correct, Jan. That is why we have freedom of testation. You cannot bring in such a clause. It would not be possible, unfortunately.
All right. Thanks, Shalosh. Thanks, everybody. Is there anybody that wants to ask a question? Just unmute yourself and then let's chat. Harry, is there a question that you want to ask?
Hi, Jan. Can you hear me?
Yes, clearly.
Thank you. Jan, where the estate is insolvent and the executor is moving away from the will left by the deceased, is he entitled to do that, to try and sell whatever he can, even though there's nothing in the will and no money is being paid to the beneficiaries?
Harry, just repeat that. I couldn't catch the question.
Okay, it's an insolvent estate.
Yeah.
The executor is selling the items in the will where the deceased has left goods through the beneficiaries. The executor is selling these estates, but there are no costs. There's nothing in this. Is the executor allowed to do this purely to pay his costs?
You remember, if the estate is insolvent, you have to compare it like if you go insolvent now, Harry, they're going to sell all your assets, pay what they can pay, and take their fees. The executors in your question. So yes, to answer your question, yes, he is absolutely allowed to do that.
Okay, thank you, Jan. Thank you very much.
Any other questions?
Yes, Jan, good morning to you and the team. Thank you for a very informative session.
Is that Ron speaking?
This is Ron, yeah.
Yes, Ron.
Yeah, I know. I see the smile. Much has been said about children throughout this presentation. However, in the real world, there are families like mine where there are no children, human children. They are animals. Now, how do I deal with that in my will and testament?
Ron, I've got my own my opinion there, but Shalosh, what's your experience that we had with animal children?
Ron, the reality of it is, obviously they can't speak for themselves, they can't control anything, they don't have capacity. So you would need to leave a human in charge of your animal children. That is the reality of it. But also think about the practical execution of that. If you, for example, have a very elderly pet, they also have a certain lifespan. And there may be a big pet, for example, let's use a dog, for example, an Alsatian who is a big pet, and you say that you leave X amount to friend A to look after the pet. And that could potentially be executed. However, what is the reality and the logistics around that friend actually being able to take on that pet and care for the pet? So these are also discussions that you need to have with the people you've identified who could potentially inherit your pets or your pet children. It's a very real question. I'll tell you of my experience in an estate that I administered many years ago. A similar instance, not married, no children, no family, was left with a couple of dogs, and asked the friend to take on the dogs testamentary provision, and it was literally impossible. And it's very sad to say and very sad to see, but the friend was left with no other option but to euthanize those pets. So very sad, but realistic.
The part of another thing to that, Ron, is how do you police that? If you say Joe Soap must get 100,000 rand, he must look after my dogs, he would take the 100,000, put them down. Who's going to police it? You will never know. So yes, it's an issue. It is a problem. My advice would be, like I think Salos mentioned it, rather chat to a friend beforehand, and you will know which friends will look after your dogs and how well they will look after them. That's the best advice I can assist you with.
Thank you, Jan and ma'am. I think if I may then summarize what you've just uttered, the assertion ultimately is that don't try and rule from the grave. I get that part, because effectively that is what I'm actually in a roundabout way trying to avoid. And therefore I would imagine that the logical way to deal with this, albeit painful, is to euthanize. Thank you.
Yeah, sad, but that's most probably in most cases the practical side of it. There's a question from Cass. Can a motor vehicle that is in an estate be sold before the estate is wound up? The estate is not insolvent. Cass, in short, yes, it can be done. It depends on circumstances. You know, if the vehicle is supposed to go to Joe Soap, it must go to Joe Soap. If money is needed and the executor decides that is the asset that must be sold first to cover the estate, to cover costs and expenses, it can be done. But in principle, to answer your question, yes, it can be done. All right, any other questions?
One more from me, Ron, if you don't mind. I know I'm holding
Yes,
the
Ron,
show.
welcome.
Okay, now, where there are no successors, in other words, beneficiaries, is Jan L Jordaan Incorporated capable of nominating, or not nominating, but suggesting or proposing entities that could benefit from such a will outcome? In other words, in simple English, as you rightly pointed out earlier, giving or donating such net assets or outcome thereof to, let's say, a form of benevolence.
Just repeat that last part, Ron, for you guys.
Donating the outcome, the net proceeds, to a benevolence of sorts.
Yeah.
Like for children with needs,
Yeah.
old age, whatever the case might be.
Yeah, and obviously we all have let's call it association, for lack of a better word, with certain organizations. Kids Haven and Jan Benoni, Moira Simpson has done an amazing job with children. So if anybody asks me, I would say to them, that's definitely one of the beneficiaries that they could consider. But yeah, I see there's somebody saying SPCA, NSRA, hospice. There are many in South Africa, but in principle, yes, we would be able to give you some recommendation. There's a question from JV. Do you recommend that clients put living wills in place, or rather have the conversation with family, next of kin? JV, I think you should have both. Have a living will, but I think it's very important that you do discuss this with your family. You know, you could keep somebody alive for months and years, and then he passes on, then you look at his will, and then you find that there is actually a living will stating that he didn't want to be kept alive. So it's very, very important that you discuss this whole practical issue with your heirs, not your heirs, your next of kin, your children, and your spouses. I hope I've answered that question. All right, anybody, any other questions? I think this is it, people. I'm just saying again, I see we were limited to 100 people, although 180 people registered for this webinar. There was an issue with only allowing 100 people. We will definitely have this session again. So you can tell your friends and family members that we will have it soon, and we will advertise it ASAP. And then we can share our knowledge with everybody again. Last thing, people, there you can see our contact details. I'm sure you know that we draft wills at no charge. There's no catch in it. That's our telephone number. That's our email address, wills@janljordaan.co.za. And if you want to visit our website, it's Jan L Jordaan Incorporated or inc.co.za. Thank you for attending, and may you all be blessed, and maybe chat soon. Thank you.